Much. Well, welcome and thank you for coming out this evening. My name is Carrie Fisher-Stone and I'm the Deputy Executive Director for the CalABLE program, which is California's ABLE program. Just curious, just a quick show of hands, how many are already familiar a little bit at least with ABLE accounts or maybe even CalABLE? Awesome. Does anybody have a CalABLE account? Great. Anybody have an out-of-state ABLE account? Okay, great. Well, my background is I'm a special needs parent. I have a kiddo on the autism spectrum. So this work has been really near and dear to my heart. Being able to be part of launching a legacy program for Californians with disabilities has just been completely rewarding, and everybody's really excited about the opportunity that this program brings us. And I'm really honored to be here tonight with Margaret, with whom I've presented on a couple of other occasions. She's been really an advocate of ABLE accounts and CalABLE, and so she's going to bring a wealth of knowledge in terms of special needs trusts and the advantages of those. You know, one of the biggest questions I always get, and Margaret probably gets it as well, is these ABLE accounts sound a lot like a special needs trust, so which one do I need? And the basic answer that I tend to give folks is that we really view these not as competing tools, but very much as complementary tools. Another tool in the toolbox when you're just doing, looking at an overall financial planning strategy for your unique circumstance. So I'll do a little bit of overview about the ABLE Act in general, and then I'll go into the specifics of the CalABLE program. We'll talk a little bit about how you can enroll. Sometimes the information I present can get a little technical, it can get a little complicated. As Steve said, if you don't mind just sort of holding your questions to the end, we'll be able to get to some of those questions at the end. Okay, so what was the ABLE Act of 2014? This was federal legislation that was signed by President Obama. And I really love the story behind this. I actually had the opportunity to meet one of the parents. She's a mother of a child with Down syndrome here in California, who was one of 5 families, a group of families who were essentially sitting around a kitchen table one day. And we're talking about the fact that, they wanted the ability for their children with disabilities to be able to save money in their own names without, hurting their very critical benefits. And for them, it was really an equity issue. They said, our typically developing children have the opportunity to have some semblance of financial stability in the future. And our other kids just don't have that, and how can we change that? And they literally scribbled out their plan on a napkin, and after about 10 years of advocacy, the ABLE Act became reality. So it really is, I think, monumental in the sense it's really a testament to what parents can do in advocacy and looking for opportunities for our kiddos. It's been heralded as one of the most significant pieces of legislation for people with disabilities since the Americans with Disabilities Act. And the thing that I think is really cool about ABLE too is it's always really enjoyed bipartisan support from the very beginning. The legislation was brought by both a Democrat and a Republican. And as they've made improvements to the bill along the way, it's continued to really enjoy that support. But the act itself, the idea was really to help relieve the significant financial burden that so many of us face when we have a loved one with a disability. We're all, I think, very intimately aware with that. People with disabilities are twice as likely to live in poverty. Many are unbanked, they're unemployed, underemployed, otherwise left out of our financial systems for the most part. So the ABLE Act really has been a game changer in, the sense that if you're finally able to save money, then that opens up all other kinds of opportunities, right? You can go to work, for instance, not just to mention the peace of mind that it brings with, that comes with being able to save for the future. So what did the law actually do, just to get a little technical here? So what it specifically did was add section 529A to the IRS code. So some of you may be familiar with 529 college savings accounts. These were modeled after those. And in California, the program is called ScholarShare. They're actually our sister program out of the state treasurer's office. And so the idea was the same. These are tax advantage savings and investment accounts that when they are used for qualified expenses, they maintain this tax advantage status. And, you know, in the case of college savings accounts, those qualified expenses are educational expenses. In the case of ABLE, they're what we call qualified disability expenses, and we'll go into that and talk about what those are in a little bit. When we say tax advantaged, what we mean is that the funds in these accounts are safe from federal, state, and income tax when they're used to pay for these qualified disability expenses. And that includes the earnings. So these are investment accounts as well. As you earn interest, that money is not taxed, and it also does not serve as income for the beneficiary. But obviously, the major advantage of this bill was that funds in the ABLE account are not counted when you're determining eligibility for means-tested programs. So those are federal programs, state and local, SSI, Medicaid, many of the ones we're familiar with. They essentially serve as an asset shield. So once the monies go into the fund, they're no longer counted as a resource by these means-tested programs. And because they won't affect benefits, again, they've really been a game changer in that they really do then become a financial empowerment tool and a financial independence tool. People with ABLE accounts the person with a disability owns the ABLE account. It's their money. So it finally does give them some more control and choice over how they control their finances. Okay. So here in California, our plan is called CalABLE. It took us a couple years to get to launch, and that was only because here in California we have really strict contracting laws. We have to contract with a third-party financial services firm to be able to run these programs, and in California we have lots of consumer protection, so it's all for the benefit of the consumer, but it required finding a firm that was going to accept our really high standard of care. And so that took some time. So we weren't first out of the gate, but you know, we definitely had the advantage of learning from other states as they've launched. There are about 42, I think now, other states operating plans. Some of those are open to residents from other states, and so you have the ability to explore those as well. And we'll talk about some of the pros and cons, maybe at looking at California versus another plan. We are a national plan, so as I mentioned, we have the ability to accept out-of-state residents into the plan. That's a good thing for us. It just increases the economy of scale. The more people we have participating in the plan, over time, the cost of the program, the fees associated with the program will just go down. So we want a lot of enrollment in the plan. Something that I do think sets us apart from some of the other states, though, is our structure. So we are our own state agency, the California ABLE Act Board. You know, most of these programs in other states are run directly out of their state treasury department. And even though we're housed in the state treasurer's office, we actually report to a 7-member board. And so that board consists of, you know, some ex officio members that oversee our financial administration of the state. So Department of Finance, obviously the state treasurer, state controller. But where we're a little different is that we also do have representatives from the agencies, the government agencies that oversee services for people with disabilities and means-tested programs. And so Department of Rehabilitation is on our board, the State Independent Living Council, State Council on Developmental Disabilities, Department of Developmental Services. All of those folks, you know, we have monthly board meetings. From the very beginning, they have really made it a priority for us to engage the disability community as we form the program. So this was one program that really, I feel, was created with a lot of input from our constituents, which as a member of the disability community was really a priority for me as well. And we launched officially in December, it was December 18th, 2018. So we've been up and running about 3 months. We're doing really well. We have over 1,000 accounts open already. So, and the feedback so far has been that the program's pretty easy to navigate. People are happy for the most part. Okay. So we'll kind of talk some nuts and bolts about eligibility. Who's eligible? The federal law says a person who became disabled before the age of 26 is eligible for an ABLE account. Now, this obviously tends to exclude a good number of people who acquire their disability after that age. People always ask me, why is it 26? And it was arbitrary. This was federal legislation as it made its way through Congress, and they worked on compromises. The thought was, well, if we let everybody with a disability participate in this program because it's tax advantaged, then we're going to be seeing a huge loss of tax revenue. So they kind of arbitrarily capped it at age 26. But there is legislation pending right now. It's making its way actually through Congress. It's called the ABLE Age Adjustment Act that would raise that age of onset from 26 to 46. And I have in a few slides down the road some ways that you can, I have the bill number and some ways that you can help advocate for that. We're really across the nation trying to, everybody is needing an influx of participants. And so this is a huge priority to be able to make sure that more people can take advantage of these. So assuming you meet, one more thing I like to say about the age criteria too. Again, it's age of onset of the disability. It's not necessarily diagnosis driven. So as an example, especially with mental health conditions that we see, say someone is diagnosed with schizophrenia, for example, at the age of 30, but we understand clearly that the person's disability likely started before that age. In that case, the person can do what's called self-certification, and it's essentially a doctor's note. They would ask their doctor to write a note that says, this person has this disability, and it started before the age of 26. So just to keep that in mind, it's not when you received did you have to receive benefits by 26? Did you have to be diagnosed by 26? Neither of those are true. It's when the disability began. So assuming you meet the age criteria, if you also meet the eligibility criteria for disability benefits or you're receiving benefits, specifically SSI or SSDI, you're automatically qualified for an ABLE account. You don't have to be receiving benefits to have an ABLE account. I'll talk a little bit about how I use my son's account. My son doesn't qualify for benefits, but I have an ABLE account for him. And again, if you don't meet the eligibility criteria for those benefits, again, you can go through that self-certification process. The definition of disability comes from the Social Security Administration. It's there. It says the person must have been diagnosed by a qualified physician with a physical or mental disability resulting in marked and severe functional limitations that is expected to last at least 1 year. So if you feel that the condition meets that criteria, you can self-certify with that doctor's note. Examples of the conditions that meet the criteria can be found on SSA's list of compassionate allowances or their Blue Book listings, and those are pretty easy to find online. Okay. The thing I want to say about the doctor's note as well, so our entire system, it's an online enrollment system, and this is how it works in most other states as well. It's essentially a self-certification system. So when somebody goes to set up a CalABLE account, they log in, they go through the process, and it says, there's a box that you check that says, I certify under penalty of perjury that I meet the eligibility criteria. And that's kind of the end of the story. The reason we tell you to get the doctor's note is because these accounts can be audited by either the IRS or the Social Security Administration. So if that were the case, then you'd want to be in a position to be able to prove your eligibility and produce the doctor's note. So it's just something we tell you to get, keep it in your files. Okay, so I'll talk about how we fund these accounts. And this is essentially the same from state to state as well, with some differences. So as I was mentioning, or as many of us are aware, before the ABLE Act, a person with a disability could not save more than $2,000 without impacting their SSI or other means-tested benefits, right? Medicaid, low-income housing. With CalABLE now, you can contribute up to $15,000 per year and up to $100,000 in total before your SSI is impacted. So a couple things there, because it can get a little confusing. The $15,000 contribution cap is tied to the federal gift tax. So that will change from year to year with inflation. Last year, the cap was $14,000. This year, it's $15,000. That's the total aggregate amount of contributions from all sources that you can put in for a year. if you do spend down the $15,000, you're still done for the year in terms of putting more money in. Now, if you're in investing and you're earning some interest over that $15,000, that's fine. Totally fine, no impact there. Now, when we get to $100,000, it's going to take some time, obviously, right, with around $15,000 per year. But once a person reaches that $100,000 threshold, that's when their SSI benefits specifically would be suspended, okay? And that SSI amount is specific, or that $100,000 cap is specific to SSI, not other federal means tested programs. You can actually save above that $100,000 in California. You can save up to $529,000 and still keep other means tested benefits, your Medi-Cal, CalFresh, okay? When you hit the $100,000 cap, as I said, your benefits are suspended. So they're not, your eligibility is not terminated. You would still maintain your eligibility, but you would have to wait until your balance went back below the $100,000 amount before the benefits would resume. And so, as I said, in California, our accounts allow you to contribute in total up to $529,000. That is the highest in the nation, so that's one difference between other states. Some states have their ABLE accounts capped at like $100,000, others $300,000 maybe. But $529,000 is the most you could contribute. Now you could earn interest above the $529,000, and that would be fine. Okay. A lot of people say, I'm worried about going over, the $15,000 or the $100,000 and losing my benefits. That won't happen with this system. The system that we've adopted will automatically reject any excess contributions. So, say grandma puts in $10,000 and then you go try to put in $10,000, it's going to automatically reject, $5,000 of that. And as you approach the $100,000 threshold, people will receive email notifications that says, hey, you're getting close to that $100,000 mark. And I know it can be a little complicated, but we can answer questions at the end. So last year when they passed federal tax reform, they had a number of provisions that were really favorable to ABLE. One of these is called Able to Work, and this is pretty cool. What this says is that if the beneficiary is employed, if they're working, then they actually have the ability to contribute above that $15,000 per year amount. Just to be clear, the money that is supplemented above the $15,000 would have to come from their own earnings. So it doesn't just automatically increase the contribution limit for all parties. Any other party would still be limited to that $15,000 contribution cap. But if the person's working, they can contribute additional. So how much can they contribute? It says whichever is less, an amount equal to their annual gross salary or the federal poverty level. So the most that they can contribute is up to that federal poverty level, which in this year is $12,140. So for instance, say the person is making $11,000 per year. That's their cap. So they can contribute an additional $11,000 on top of the $15,000. So there is the potential to save, roughly $27,000 per year if the person's working. A couple of basics I'd just like to point out with ABLE accounts. If eligible individuals can only have one ABLE account, and I point that out because for those of us who are familiar with college savings accounts, you can actually have multiple college savings accounts. The beneficiary, as I said, is always the account owner. This is their money. This is their account. Now, if they're a minor, if they don't have capacity, if they want to elect to have someone help manage their account, then they can have what's called an authorized legal representative. And the authorized legal representative term is laid out in the federal statute, so it's pretty specific. It's either a parent, and it doesn't, by the way, specify parent of a minor child. It says parent, and we've consulted attorneys about this, and it's parent. So if you're a parent, you can serve as an authorized legal representative. Legal guardian or conservator or power of attorney. Some people have wanted to see this definition expanded. For example, those of us who, beneficiaries who are using rep payees. Unfortunately, a rep payee at this time does not have the ability to open or manage an account on behalf of a beneficiary. Some parents are also rep payees. That would be fine, right? The parent would still have the authority to do that. There is some discussion that at some point, there's a lot of groups that are lobbying at the federal level to try to expand that definition so that more people can take advantage of these accounts, but there are a lot of concerns about fraud as well. So right now, this is pretty much what we have. Again, I mentioned that these ABLE accounts are asset protected, and the reason I make the distinction is because one of the biggest misconceptions I hear is that you can now shelter income with the ABLE account, and that's not the case. So as an example, a lot of us are familiar with the fact that with a lot of these programs, you'll have an asset test or a resource test, and then also an income test, right? Like with SSI. A lot of people call and they think, oh great, now I'm gonna take my income or my SSI payment, or my income. It could be income from any source. I hear I have a pension, child support, alimony. If I put it into the ABLE account, then I won't be subject to any reduction in my SSI. And that's not the case. So just to make that perfectly clear, when these programs are looking at ABLE accounts, they're disregarding them as a resource. They're still going to apply whatever formulas they apply on the income side. They see the income hit, they're gonna apply those formulas and do whatever it is they do. That's still going to happen regardless of whether or not you put your money into the ABLE account. These accounts can function in different ways depending on a person's circumstances. In my case, I'm using this as a long-term savings vehicle for my son. He's a little bit higher functioning on the spectrum, and I'm hoping he'll go to college. As opposed to opening up a 529 for him, I've opened up the ABLE account because if he doesn't end up going to school, I can still use the accounts, the monies in his ABLE account for any expense, essentially. Whereas if I had stuck with the 529 account, then I'd be looking at a tax penalty, right, if I didn't use the money on his behalf. But other people will use these more day to day. So for a lot of people, especially like I mentioned, some of our people who have been unbanked, they haven't had a checking account before, or they're using these as a more transactional day-to-day basis to pay for basic living expenses, because with ABLE, you're allowed to do that. Some people will use it more that way. We have an FDIC insured savings option, which kind of acts like a savings checking account. And so other people, they'll be saving for the long term. Other people will use these more day to day. And again, these monies stay tax exempt as long as they're spent on those qualified disability expenses. So what are those? Okay, so this is pretty exciting. What's a qualified disability expense, or what we call a QDE? And this first bullet point actually comes out of the federal statute, and it says, any expense related to the designated beneficiary as a result of living a life with disabilities that helps maintain or improve your health, your independence, or your quality of life. That is very broad, and it was deliberately so. The ABLE Act stands for Achieving a Better Life Experience, and the idea was that you should be able to improve your life experience. There's specific categories that are referenced. I actually brought a fact sheet, which some of you may see. It's a double-sided 6-pager that has specific categories listed out. So what kinds of things count? Education, housing expenses, transportation, healthcare expenses, but there's a host of other things. But the bottom line is that if the expense is considered to improve your health, your independence, or quality of life, we consider it a qualified disability expense. CalABLE and other ABLE programs don't determine what is a qualified disability expense. Some people don't like that. They get a little nervous and say, well, what if I spend it on the wrong thing? It's very difficult, we think, to decide at this point what is not a qualified disability expense. So some things we've agreed to as a consortium of states is gambling, right? Alcohol. Yeah, alcohol, what we call the fun stuff. But people will ask me, well, what about a vacation? And we say, yes. Does it benefit the person's quality, the beneficiary's quality of life? You could definitely, purchase their transportation for the trip, their food, if they had a personal assistant with them, their, transportation. Where it gets a little fuzzy is, can I buy a ticket for everybody in my family to go to Disneyland? No, because the money has to be for the benefit of the beneficiary. You can take a non-qualified disability expense. You can do this in college savings as well, and like with some retirement plans. That's not illegal. But if you do that, then you're going to lose that tax advantage protection. Expenses then will become subject to regular income taxes, and then you'll see some tax penalties as well on the earnings for whatever purchase that you're making. But the biggest thing here is you probably don't want to venture with that too much, because then your benefits are potentially at risk, and then they could become a resource. I have an asterisk by housing because there's a couple of little things I always like to explain about housing. Social Security Administration did put a little caveat in what we call their POMS, their operating manual, their treatment of ABLE accounts, that says, it's one rule that says, if you are using these funds for housing expenses, rent, for instance, then they want the money spent in the same calendar month in which it was withdrawn. Otherwise, it will then become a resource. That's not the case for the other qualified expenses, just for housing. So as an example, you're going to use the money to pay rent. You take the money out on the 1st, that money needs to be gone for the rent by the end of the month. Otherwise, Social Security will then consider it a resource. So there is that caveat with housing. And again, feel free to, I know you know this stuff too. And I think Margaret will touch on this as well, but the ability to use ABLE funds is really huge for housing expenses is really huge. The SSI rules make it pretty tough for family members in particular and others to support people with disabilities. Many of you may be familiar with what's called, what SSA calls in-kind maintenance and support. So this is a term that refers to anytime food or shelter is being supplied or paid for by somebody other than the beneficiary. And so, for example, if a parent were to provide or pay for their disabled child's rent, then they're looking at potentially reducing the SSI benefit by up to 1/3. In this case, if you're paying out of the ABLE account, it's considered a qualified expense. It's not going to be considered in-kind maintenance and support, and that reduction won't happen. I mentioned tax reform. With tax reform came a lot of positive changes to ABLE. We talked about Able to Work. One of the other things it allowed now was rollovers from a 529 college savings account to an ABLE account. So some of us set up 529 accounts for our children who later became diagnosed with a disability. Now there is the ability to roll those funds from the 529 over to the ABLE account. Just something to mention for right now, in California, we're going through the legislative process right now. We've introduced a bill to pursue tax conformity with this federal law, state tax conformity. If you were to roll over today in California, then you would be free from any federal tax penalty, but you would be subject to a state tax penalty. And that's something that we're trying to eliminate, but it's just something to keep in mind. We have had some families who have tried the rollover process already and were kind of surprised, like, I didn't know I was going to take a tax penalty. But we do have a bill that's been introduced that will try to eliminate that. The other thing it did is it gave folks access to the Savers Credit, which is, if you go to file your taxes, it's a credit that you can take assuming you meet certain income criteria. It's typically been reserved for people who are contributing to retirement. Basically, you get a credit for every $2,000 you save. The provisions are kind of complicated. There's a lot of rules around it, so this is where I would tell you to consult a qualified tax advisor for some of those provisions. Okay, I just have a quick slide on using CalABLE. CalABLE as opposed to, or not really as opposed to, some of the advantages of CalABLE and ABLE accounts when we're looking at both ABLE accounts and a special needs trust. And I know Margaret's going to be talking about the trusts and some of the advantages around those. So I'll just highlight a couple of benefits with the ABLE account. Obviously, one of the biggest benefits is cost, right? These are free to set up online. You just need with CalABLE, you need a minimum deposit of $25 to start, so no attorney's fees. With ABLE, we mentioned you can pay your housing expenses without reducing your SSI benefit. Again, with ABLE accounts, as we mentioned, we have that favorable tax treatment. And so your money's growing tax-free, and your qualified disability expenses are not considered income. And as we also talked about, the ABLE account holder, the beneficiary, is the account owner, and the person with the disability can use their own funds, as opposed to a trust where there's a trustee who's controlling the assets. One of the other differences is you can open the account at any age, assuming you meet that age of onset criteria. All we care about is the age of onset criteria, but I think with some trusts, you do need to be under a certain age. Yeah. And we also have up at the front a handout, which you may have picked up, that Margaret put together. It's a comparison chart looking at pros and cons, or just comparisons between ABLE accounts and special needs trusts. So that's very helpful. So why would you pick CalABLE over another state? All of these programs tend to operate the same way, I'll say that. There are minor differences in terms of cost, in terms of investment options, and just general features. Some states have a debit card. We will have a debit card. Some states don't. And so it really kind of depends on your individual circumstances again. And I'll give you some resources where you can kind of look at other plans as well. We have an online enrollment process that's super easy. I did it myself for my son. It took about 15 minutes, and we're hearing it takes on average about 10 to 20 minutes. We also have a lot of safeguards. It's online. That's another issue too, is some folks have said, why isn't there a paper application process? We don't have a paper application. And that was deliberate too. Anytime you do things in paper, it ratchets up the cost. We really wanted this to be affordable for folks. And so, having those, keeping the cost down and ensuring the long-term viability of the plan was really crucial. But we have low fees, we have competitive fees with other states, and I'll give you a little breakdown momentarily of what those look like. In terms of overall cost, we fall in kind of the bottom tier part. Contributions into the account, it's pretty simply done. You can do that a couple different ways. The most popular way is through electronic bank transfers, or what a lot of us know as ACH transfers. So in my instance, I have my son's account linked to my personal bank account, checking account. And so I have on a recurring basis, once a month, $100 going into his ABLE account automatically. You could do that, you can set up recurring contributions, you can do that one time. Folks can contribute via check. So checks can be mailed into the program. Checks can also be endorsed or written over to the program. Say a check was made to the beneficiary, you can actually endorse that check over to the plan. One of the beauties about CalABLE is that the funds can come from any source. And so it can come from the beneficiary themselves, it can come from a friend, it can come from a family member, it can come from the trust. That is one of the beauties about this. Something that we also have that's kind of cool is an e-gifting feature. This allows you to, a lot of us are familiar with crowdfunding or like GoFundMe. This gives you the ability to send out a link to select people and say, solicit contributions essentially to your ABLE account. And I've already seen this in action. One of my friends, her young daughter was having a birthday, and she sent out a link to everybody and said, in lieu of gifts, would you please consider making a contribution to my daughter's ABLE account? And she got a lot of contributions. And it's really cool. It has a way to, send automatic thank yous and that sort of thing. Other people have used it to kind of crowdsource, I'm saving up for a wheelchair. Will you help me reach my goal of, and contribute to my ABLE account? And it's a really easy process. And then the other item we will be having soon, another feature, is the prepaid debit card. This will be a loadable card. This isn't a debit card that has, or like an ATM card that has a direct line to your entire account. Again, this is a safeguard, a safety measure. It's a loadable card. So for instance, With my son, I plan to really use his ABLE account as very much a financial literacy tool for him. I want him to learn how to manage money, use his money, but I don't want him to have complete access to his entire account. So in this case, as the authorized legal representative, I could go in, say he wants to go out with friends to the movies or something. I could load $30 onto his card. The card's in his name, it's also in my name. He could take the card out and he could, go to the movies with his friends. He could buy a coffee. It'll be able to be used wherever Visa is accepted. Probably the biggest feature with going with California is that we did something really good here. We passed legislation that removed what's known as the Medicaid clawback from these accounts. So some of us may be familiar with the Medicaid payback provisions that exist. This essentially, the federal law essentially said that individual states had the ability, once a beneficiary passes away, to file a claim against the ABLE account to repay themselves essentially for any Medicaid that was spent on the person during the time that they had the account. Obviously not a popular provision with folks. They said, we're not going to save hundreds of thousands of dollars in these accounts only to have the money go back to the state. And so we were the second state, and I think there's about 5 now that actually did pass similar legislation that says no, once the beneficiary passes, they cannot file that claim. Medi-Cal specifically cannot file that claim against the ABLE account. Now, in rare circumstances, funds that transfer to an estate may still be subject to estate recovery rules. There's Medicaid estate recovery rules. They're very specific. The person has to be over the age of 55. They have to be receiving certain services, but they can also apply for hardship waivers. So all this to say that in terms of recovery, it should be a rare event. But the thing to keep in mind is that this protection only exists for the California resident with a CalABLE account. So this is one of the advantages to staying. And if you're using Medi-Cal, you probably want to stay with the California plan. If you go with an out-of-state plan, that state's Medicaid authority could file the claim against your assets, which would include potentially the CalABLE account. I'll talk about our investment options just briefly. A lot of the materials that you were given in the enrollment kit, the envelope, go more into investments. Our enrollment website goes more into investments. We kept this piece simple. This was the result of stakeholder feedback. A lot of our members or participants are brand new to investing. And what we were hearing from other states was, a lot of times they go sign up, they get to the investments page where they need to select their investments and they're like, what is this? And they were losing a lot of people there. And so at least to start, we've kept it really simple with 4 different investment options. That's subject to change in the future. If the board wants to have a discussion or we start getting stakeholder feedback that they want to see more investment options, we can definitely look at that. But this is one of the differences between other states. For instance, a state like Nebraska has something like 17 investment options. And some people who are more savvy with investing and they want to take a look at those, that may be a consideration for them. But as I mentioned, we have an FDIC insured portfolio. This is essentially your savings option. Your principal's protected. You're not going to lose any money, but you're not going to earn a lot of interest over time. And then we have a conservative option, a moderate option, and an aggressive option. You're able to change your investment options twice per year. And you can actually spread out your investments in different ways. So you're not just limited to picking one option. So as an example, this is a screenshot. I don't know how clearly it's coming through, but when you go to sign up or you make a contribution, it will say, how do you want to allocate these funds? And so in this example, I've got 25% going to the conservative, 25% to the moderate, 50% to the aggressive, just as an example. You could do 100% in one, you could do 50-50. And again, so you do have the ability to customize that a little bit, and you can change it twice per year. So here's a snapshot of our fees. Before I list these out, I'm going to kind of give you an overview of the fees, but then in the next slide, I'll translate this into a more tangible example of what the fees actually would look like. Every state has what's called an account maintenance fee. This is just the cost of running the program. They tend to be pretty low fees. Here in California, ours is $37 per year. That's assessed monthly, so essentially $3.08 gets deducted from your account each month. Across the board nationally, we see anywhere from actually Tennessee is a state that has zero fees. They have zero account maintenance fees. They were able to do that because they have a really generous legislature that paid for their program outright. But you'll see a range of between, zero in Tennessee to about $60 per year. And then depending on the investment option, as well as how much is in the account, you have what's called an underlying investment fee. These are also called basis point fees. They're essentially a percentage of the assets that are in the account. And so again, depending on the investment option you select, those investment fees run anywhere from 0% with the FDIC option to a tenth of 1%. The other fees that we have, the state administrative fee, again, this is another basis point fee, so less than 0.5% on the assets in the account. That fee is directly reimbursing the state for the general fund loan that we needed to be able to launch the program. Then you have some other incidental fees that you see in other plans, $10 for if you want paper statements. A lot of us do things electronically, so that doesn't tend to be an issue. If you bounce a check, you're looking at $20 every time that happens. And if you are writing checks from the program, you do have the ability to also withdraw money via a check that can go to the beneficiary, the authorized legal representative, or a third party. Just keep in mind, if you're going to be using that method, there is a $5 fee every time you issue a check from the plan. So most people are doing electronic withdrawals. We'll talk about withdrawals in a moment to avoid that cost. And then once we have the prepaid card, obviously, that will be another method. And as I mentioned, there's no cost to get online and enroll, but there is a $25 minimum deposit to start. So here's an example. This assumes that you have $3,000 in your CalABLE account. So say you have enrolled in the FDIC option, your total cost is $37 for the year. Those are your fees. Now say you have the $3,000 in the account and you're investing in the moderate option. You're looking at about $53 per year in fees. So obviously those are going to fluctuate, again, depending on, if it's less than $3,000, obviously lower fees, but the fees do go up as the assets grow, which is why we need a lot of people in the plan, because as I said, over time those fees will go down. ScholarShare, our 529 program here in California, they have no fees now. They've been in operation 20 years, and so as participation grows, those fees immediately go down. So this is what it looks like when you go to our enrollment site, calable.ca.gov. I really recommend that people kind of take some time to click around and familiarize themselves with the different topics before they get started. But once you are ready to open your account, it's pretty straightforward. You see that gold button at bottom left that says open an account. You click that. You're going to be prompted to have some information ready. So these are your basic, social security number, some contact information. If you're going to have an authorized legal representative, you'll want to provide their social security number because they will do an identity verification on that person. And then any bank account information. If you're linking a personal checking account to the ABLE account, you'll want to have those bank account details. Just again, briefly, how does money come out? Very simple. You log in to your account and request your withdrawal amount, and then you pick your distribution method, which currently is an ACH transfer to a bank account, and it can be any bank account. It doesn't have to be the beneficiary's personal bank account or the authorized legal representative's bank account. It's just, a checking account. There's no limit on the number of times you can take withdrawals, and there's no cost to do any of those electronic withdrawals. Again, if you're going to use the check, just a forewarning, you are going to pay that $5 fee. And again, once we have the debit card, we'll be able to, you would go in and select, here's a withdrawal. I want it to go to the prepaid debit card. It'll be loaded that way. Something to keep in mind, we don't track expenses. We don't ask you what you're spending your money on. We do recommend that people keep receipts, and that's because, again, you could be audited by the IRS, and so you just want to be in a position, if ever asked, to say, this is what I spent my money on. We do have a customer call center that is, so far, we've been hearing great things about it. They are not new, we're new, but they're not new to ABLE. They've been servicing other ABLE plans throughout the country for the last 3 years. They're open Monday through Friday, 9 to 5. If you're having difficulties with, they're really good with helping people navigate the enrollment process. Some people are like freaked out by getting on the computer and navigating that. They will really take the time to help people walk through the process and answer any questions. They're really knowledgeable, but if you do have issues, you can always contact us as well, and we can help facilitate or escalate anything. And just briefly, I always like to give folks these couple of resources because they are really handy. One is called the ABLE National Resource Center. These folks are out of DC. They're a nonprofit that really worked with all of the states as we launched our different ABLE programs, and they have they know everything there is to know about ABLE. They have resources galore. They have pages of webinars galore, things like how to, use your ABLE account with other financial planning tools and a special needs trust. They also have a state comparison tool. So I was talking about the fact that you could compare programs from state to state. They have a tool where you can go in, you could select a couple of states, California, Ohio, Oregon. Then they have a drop down that shows here's their cost, here's their investment options. Maybe their state offers, their residents a tax deduction, any kind of special feature that they have. And then I also like to refer folks to Disability Benefits 101, db101.org. One of the things I often hear when I give this talk is this all sounds really great, but I'm really limited in my ability to earn income and worried about working because I might lose benefits. And we want to let people know you can work. You can work. And this site, I really like it because it has a lot of, and it's interactive information as well, about disability benefits, work rules, and different work incentives that can really help people, maximize their benefits and learn how they can, keep their benefits while they plan to go to work. Both SSI and SSDI have work incentive programs, and so I just always really recommend that people check that out because I'm surprised at how many people are sort of not very knowledgeable about those. And like I said, it's not just it has great information on all the different benefits in the state, but it also really can act as a decision support tool as you're thinking about, should I return or should I go to work? Just briefly, we have some, this program's going to be evolving. It all depends on support from our stakeholders. We have a couple of bills going through right now. The federal one is the one I mentioned earlier, the Able Age Adjustment Act. That's going to raise that age of eligibility. Here in the state, though, we do have a bill that's been introduced that would offer a tax deduction for CalABLE account contributors. So that would be a nice feature to have as well. And then I mentioned the other bill that's seeking that tax conformity with the federal reform bill so that there's no penalty for rolling over funds from a 529. If you're interested in learning how to advocate for those, get in touch with me. We can give you support letters and all kinds of stuff. So I head up outreach for CalABLE. We are an agency of 3 people total. And so, we need this is California. There are so many groups to reach. We need everybody's help on board. And so, opportunities like this to present are awesome. If you're associated with a group that would like to host a meeting, let us know, and we'll try to fit it in. There's other ways to get involved, though. If, we have different advisory councils where we meet a couple times a year and we talk about kind of hot button issues with ABLE. We want to hear also how this is working for people. So like I said, we really prioritized making this a program that would best serve the needs of our population. And so to that end, we really want to hear feedback. What's working, what's not working, how do you see this working better? And also, if you have your own networks, can you help us get the information into the community? Maybe you're associated with a parent group. Maybe you just want to share things on social media. I'm going to be spearheading a ambassador program very shortly, which would, the idea is that we get a couple of really key activist type people who are excited about ABLE, using ABLE, and can really help us get into different networks and help folks learn about the program because it is so life-changing for so many people, and a lot of people still don't know about it. We're on social media, and our contact information are on the slides as well, so feel free to get in touch anytime.
I've been a estate planning attorney for almost at least 25 years, and I have also moved into the special needs planning area, which I find very fulfilling, and my practice does a lot of special needs trusts. There was a day several years ago when I decided to go down to the treasurer's office and find out for myself what was going on with the ABLE board, and that's how I met Carrie, and she has been the backbone of this. She's gone through a couple directors and she's hung in there, and it was very exciting in December when they finally launched their program. So I'm going to talk about special needs trusts for a while, and then I'll go into a little more about the overlap with the ABLE account. Has anybody had experience with a special needs trust? Are you the trustee of one maybe, or created one in your estate plan? So there's a number of experienced people. I'm going to go through the basics, but all right. So what is a special needs trust? It is a trust where money can be held for a beneficiary who is disabled. The money in the trust will not disqualify them for public benefits. This is an exception to the Social Security laws. So it just wasn't imagined by some attorney somewhere. The Social Security Act was actually amended to say that yes, parents can leave money to their child. The child could still be on public benefits if they keep it in a very specific kind of trust. So that's why there are so many details about the trust, regulations, the POMs Carrie mentioned, which are Social Security regulations. So there's a lot of details that we have to be careful about. But it does preserve the eligibility for SSI, Medi-Cal, Section 8, some other public benefits. The other thing that people don't always focus on is that if you do in your estate plan prepare a special needs trust for your child, it provides a management system for this money. You can say that the trustee can hire a care manager. You can say who the trustee is. You can provide a trust advisory committee. I like to look at it as the instrument that will set up a roadmap for care of your child or other beneficiary after you're gone. So we look at it in a broader way. Yes, it keeps the eligibility, but yes, you can provide those details, which is going to help the beneficiary later in life. The special needs trust, like all other trusts, has three parts. There's the grantor. There's the person who puts money in as the grantor. It might be the parents of a beneficiary. There are some trusts where the beneficiary is in an accident, has a personal injury judgment, so that's another kind of trust where they are the grantor. The trustee manages the assets. I'm not going to go into this too much, but that's probably the most important decision you make in establishing a trust. Are you going to use a family member? Are they willing to learn all the rules? No, you can't distribute cash to the beneficiary. It will reduce their Social Security benefits. No, you can't pay for housing. It will reduce. There's a lot of rules. Plus, they have to be somebody competent to manage the money. And so there's a lot of consideration that should go into the trustee. And then, of course, the beneficiary is the person who receives public benefits. So who needs a special needs trust? That is a question that really is a very difficult question for a lot of my estate planning clients. They have a child, perhaps the child is young, they're not sure how things are going to turn out, they don't know whether they need one or not, but the special needs trust is for a person who depends on what I call needs-based or mean-tested public benefits. So if you think there's somebody like that in your family, it's important to watch for that person and make sure that any money that goes to them when somebody dies, either you or grandma or some other family member, that it goes into a special needs trust. Do all people with disabilities need a special needs trust? Basically, to be eligible to have one, they need to be disabled under the Social Security Act. Carrie went through some of that. And they want to be somebody who wants to remain eligible for the public benefits SSI, Medi-Cal. So that's the person who should be the beneficiary of the special needs trust, whether they're the ones that create it or more likely it's going to be a trust created by the parents. So now we get to look at public benefits, because very often people come into my office and say, well, you know, they usually know about their child, but who they don't know is about their grandchild. Yes, I know that our grandson has autism, is on the spectrum somewhere or whatever, and is getting benefits. Okay, so we go, well, what kind of benefits are they receiving? So the benefits are means-tested public benefits. We've been talking about them, SSI, Medi-Cal. Then there are benefits that people are entitled to, entitlement benefits. And they are entitled to those benefits because somebody worked, somebody paid into the Social Security system. All of us, when we get to be old enough, are going to get Social Security because we paid into the system. We're also going to get Medicare because we paid into the system, and if we become disabled, we will get SSDI because we paid into the system. Other benefit programs are Section 8, which is a housing benefit, and that's to many extent means-based, and then regional center benefits, which are not means-based, but people often get them. So it's important, if you're deciding, does this person need a special needs trust, you want to look at what they're receiving. A lot of children receive entitlement benefits because their parents worked. So, for example, if your parent becomes disabled and then you have a disability, you were disabled before the age of 22, another thing, then your child may be able to collect SSDI. I advise clients to go on the Social Security website or to have someone related to the beneficiary go on the website and find out whether they're getting SSDI, SSI. It makes a lot of difference if you're structuring a gift, you know, usually inheritance to that person, to find out what type of benefits they're actually getting. And we've talked about this a little bit earlier, the SSI requirements. There's an income test, and then this resource test is what is really hard, the $2,000 account for a single person. They can own a residence. There are different things there, but Medi-Cal has similar requirements. I'm not going to go into that. Each state is a little bit different. But often people say, well, I'm going to leave a lot of money to my child. You know, why should I have a special needs trust? Because a special needs trust is for the whole life of the person. It does not say that the person can ever receive the money personally, because if they do that, then they're going to be disqualified for their benefits. So it's a fairly restrictive document. Okay, people say, well, our family, you know, we're not super wealthy, but we would be able to leave our child quite a bit of money. Why should we put it in a special needs trust? But people should really look at what benefits are available. The SSI benefit in California in 2019 is $931. So that is supposed to pay for the housing. That's why you can't use other money to pay for the housing, because in theory, but not in practice, as we well know, that's supposed to pay for the housing. But if you're eligible for SSI, then you're eligible for Medi-Cal. And people have heard good and bad things about it, but for somebody who has a lot of medical needs, that's probably the really essential thing that you have, that you need to keep the eligibility for, because it pays for primary medical coverage, medical-related costs. There are services where somebody can come into your home and get paid for taking care of your child. That has to do, and many parents are actually the worker that gets paid to take care of their child. So it's in-home supportive services. All this comes through the Medi-Cal and the eligibility for that. So it is probably a decision to be made if you're deciding in your estate plan whether you need a special needs trust, that you ought to look at it long and hard. And they're actually financial institutions who, you know, there's a couple of teams in this area who deal with families with a beneficiary who may have special needs, and they do a projection, what will happen with public benefits, what will happen if they just inherit the money from you and we invest it. So there are ways of looking at this and projecting it out to see, but you never know how long somebody's going to live, and to just turn your back on the public benefits is a major thing to look at. And even, for example, as we all age, nursing home care, Medicare is not going to pay for skilled long-term nursing home care. And it could be that your special needs beneficiary is going to be around for quite a while, and at the end, because of some of their disabilities, may need nursing home care. So it's you look through the life spectrum and see where they're going. Okay, so the interesting thing about special needs trusts is there are several different kinds, and it gets kind of confusing. The trust that is on that chart that I have is called a third-party trust, and that's probably going to be more common. And that's the first one. The third-party trust is where a third party, like the parents, anybody but the beneficiary, provides the funds to create the trust. And that trust is not subject to any Medi-Cal recovery. The funds were never the beneficiaries. The parents of the beneficiaries said, we're going to leave the funds to, Johnny's special needs trust, not to Johnny himself. So that's why I just use that trust on the comparison, because that's the one that you're going to see the most. But we also have what's called the first party, and that's when the funds actually belong to the beneficiary. So how is the beneficiary who possibly can't work, and how are they going to get these funds? So they get them often if there is the personal injury case where there's a terrible traffic accident. It could be a birth injury. People end up with funds that could otherwise keep them from being on the public benefits. But again, this exception in the Social Security law says that you can get $1 million judgment for your traffic accident, but if you want to remain on SSI and Medi-Cal, which a lot of the people who elect to do a first-party trust were already on that. Maybe they don't have too many assets, or maybe they went to somebody who helped them project out, even if you did win $1 million, are you really going to abandon the medical care available through being eligible for the means-tested benefits? So these are the disabled beneficiaries' funds. And the other way that they get the funds is that somebody made a bad mistake in the estate planning. Grandma's trust said everything to my two children, but if one of them dies before me, then the funds go to my grandchildren. But grandma forgot to tell the estate planner that one of the grandchildren was on SSI. They should not get that money. So if grandma dies, we do special needs trust to put this money in the trust, but unfortunately, her estate plan said it goes directly to my grandchild, so that money can go in a first-party trust, but that money is going to be subject to Medi-Cal reimbursement because it was money that belonged to the beneficiary. So this is a way that we can keep that beneficiary on the needs-based benefits, but unfortunately, grandma's money, if there's any left over, is going to go to reimburse Medi-Cal for expenses. So it's a good, and the other way that the disabled beneficiary might get money is through a divorce. So you have to be careful in the divorce situation. There's child support, but should that be paid directly? That there is California law actually, where if you have an adult disabled child, you still could be subject to paying this child support for that child, even though they're an adult. So if there's a divorce situation involving somebody with a disability, we want to look and make sure that that money doesn't go to them for their benefit. So the first-party trust is usually, the first-party trusts are even more complicated and confusing, and Social Security is much more worried about them because the money belonged to the beneficiary and it got put in a trust, and therefore the person still remains on public benefits. So we have to notify Social Security when the money goes in the trust. They are auditing those trusts a lot more. They're causing a lot more trouble because it's just cheaper for the government not to let these people be on disability when they be on these benefits when they have money. But, and actually, it used to be that they could only be created by a parent, grandparent, guardian, and the court. But in 2016, a law was passed saying a special needs beneficiary with capacity could create their own trust. And that was a matter of advocacy. I believe that an attorney who was very involved, who was blind, but he also had some other issues and wanted to continue on the benefits, but had complete capacity, could not create his own trust. So now a first-party trust can be created by a beneficiary with capacity. The advantage of this is the other trusts are usually subject to court supervision. Accountings have to be sent to the court of the first parties, not the third parties. So this is good that the beneficiary can create their own and they're not going to the court. The first-party trust, Carrie mentioned this, can only be used by somebody who's under 65. So I got a recent call from a personal injury attorney who said, my client who was actually in an injury in the nursing home, had something happen to him, is 85. So what could happen? There is a pool trust. It is a trust run by a nonprofit. The money is invested by the pool trust. When the beneficiary wants the money, they need to make a request to the pool trust. So in all these cases, would an ABLE account work? And an ABLE account could work, except the one severe limitation on the ABLE account is the $15,000 a year. So we've gotten questions about that, and unless the inheritance is really, really small, it's not going to work in an ABLE account. But the two work together, which is really good. All right. So I have a little bit more about the first-party trust. They're just not as common. The third party, it should be part of the estate plan of anybody who has intention of leaving some money to a beneficiary with a disability. At least it should be considered carefully. And people come in and say, well, I don't want to do a special needs trust. It's going to cost more. It sounds complicated. Johnny is disabled, but his sister Susie is really reliable. So I'm going to give all the money to Susie, and she can take care of Johnny. So is that a good idea? Not really. So something could happen. Susie could forget to pay her income tax and have creditors. Susie could get divorced, and her husband could run off with all the money. Susie could decide that she's really tired of being involved with Johnny and doesn't want to do it. And so it is not really good to leave it to other family members. You could, and that's usually they say, well, I'm going to not give any to Johnny because Susie's going to take care of it, so I'm going to disinherit him. So there's a lot of things that could go wrong with that. The other big decision, as I was talking about before, is who should be the trustee. And in my practice, it's very often a family member, and I try to educate them in what they're getting into. But the trust lasts for the life of the beneficiary. At a minimum, we try to put a succession plan in the special needs trust. If, Brother Johnny can't do it, then somebody else does it, or somebody else has the authority to appoint a successor trustee. If there is a vacancy in the trusteeship, California law says the court can appoint a successor, but that's a very expensive process to go to court, and somebody has to petition, I want to be the successor of Johnny's trust. We had Susie in there, but she just died and there's nobody else. So I try to make my trust where somebody else can appoint a successor trustee, and that the family thinks about, Johnny's young, who's going to be the trustee when he's 65? So that is kind of an awesome thing to think about. It's a management system potentially for the rest of his life. There are these are kind of more modern things that are going on. You can have a trust advisory committee, and you could have a trust protector. So these are the more complicated trusts. They're probably for the larger estates, but just for example, the trust advisory committee, I had a client who actually just managed to get divorced, but she was fairly wealthy. She had a 22-year-old daughter who was the sister of the special needs beneficiary, who was another daughter. did she want to make the 22-year-old the trustee of the trust? And she decided no, she would use the bank because there was a lot of money and the trustee has to make it available for the needs of the beneficiary, but the other job is simply to invest it. So she decided that the daughter should be on the trust advisory committee and that her niece, these were two people who were very close to the girl who was the beneficiary. So they had the ability to fire the bank trustee if the bank was not being responsive, if they didn't like the bank. And they kind of were watching over, but they weren't involved with the day-to-day distribution. So again, this is probably a larger estate. There's that. There's also a trust protector, and sometimes we put somebody in who can just plain fire the trustee or can appoint a new trustee. And maybe it's not somebody who wants to manage the money. But if it is a family member that you're going to make as trustee, they need to be really educated about what types of distributions could disqualify the beneficiary for their public benefits. And then with a beneficiary with a certain amount of capacity, perhaps a mentally ill beneficiary, they have to have the strength to deal with this person who says, you're sitting on my money, why can't you give me cash? Why can't you buy this for me, that for me? So it's not an easy job. It's for very brave people to do it, but it's necessary. Okay, so special needs trusts can pay for a whole lot of things. There's a huge list here. So once the trust is funded, as I say, it's very often on the death of somebody, like the parents of the beneficiary. You can create a standalone trust, which is not part of your estate plan, and that's what I really recommend these days. That trust is, when the trust gets funded, it often, Social Security wants to see it. If it's embedded in your estate planning documents, your whole estate, your whole living trust goes to Social Security and they look it over. So the standalone trust is a separate legal document. It also means that other family members can use it. So if grandma gets educated and said, well, I want to give something to my grandson, or even if my son dies, I want my grandson to have it, we can tell grandma's estate planning attorney, just say it goes to the Johnny Special Needs Trust, which was established separately. So if you get the standalone trust, other family members who are interested in contributing to it can do that. And that's really helpful. So the Special Needs Trust can pay for a lot of things, but the trustee has to spend the money. The beneficiary cannot get the cash and run down to the store and get all these other things that they would want to get. The Special Needs Trust can own a house. That's a legitimate thing. The beneficiary actually can also own a house because, as you saw, the house is an exempt asset, but you have to look at the beneficiary, their capacity, their ability to handle all the things going on with the house. So that is, there's a lot of questions about that, but the other thing is, what can they not pay for? So we've already mentioned this, and this is where ABLE comes in. They cannot give cash directly to the beneficiary. And again, if the Special Needs Trust pays for food, shelter, or medical care, then it will reduce the SSI check. So we don't want that to happen. We're doing this to preserve the Social Security. Okay, so this is your handy dandy chart that you all can take home and study in your spare time. Yours is one page. We squished it down. This is 2 pages. So this is comparing the ABLE account with the third-party Special Needs Trust. So the ABLE account are persons disabled before the age of 26. And that's, I think, something that Carrie is working on through legislation to try to make it older, because we have somebody with a Special Needs Trust and they would like to have the ABLE account go with it so the beneficiary could have some cash, so housing would be paid for. But the first question is, what's the onset of age of disability? And especially, again, with mental illness, it's well after age 26. So we're hoping that gets extended. The third-party Special Needs Trust, anybody with a disability can use it. There's no age limits. On the third party, there's not even that age 65 limitation. So again, the 2 things who can fund an ABLE account anybody, including the person with a disability, who can fund the third party, anyone except the person with disability. So again, it can be, you can create your standalone and people can give money to it. You, as the parents of somebody with disability, would not want to fund the trust during your lifetime, because as long as you have the money in your hands, you're going to make sure that your son or daughter is being taken care of. You're going to be paying for the things that you need. So people get, I think that's kind of the confusing thing with the ABLE account, because you certainly would want to establish the ABLE account now. It can help out without the special needs trust, but again, in that case I mentioned where the parents want to help with housing and they can put money into the ABLE account. The situation I talked about, they were putting in $1,000 a month. So what does that add up to? It's $12,000 a year. So it's under the limit, and they're taking it out in the month, and it's being paid to the landlord. So that's where ABLE account can be used kind of as a pass-through. And so that can be very useful. The other thing is, Carrie mentioned, just the plain savings plan. The person who wants to work can work. They can save their money from their work. They don't have to be below $2,000. And actually, there are some children who get money as long as their parents are poor. And I've done seminars other places, and the parents say, you know, I can't get a better job because my child, if I make too much money, my child will not be able to get the benefits that my child needs. So this is a little expansion here that would help. Okay, the ABLE account, each person can only have one. The special needs trust, everybody in the family can make one. There can be grandmas and everybody else's, but it's better to try to consolidate the family resources. The ABLE account, the person with a disability or their guardian or conservator or agent can control that. And the third party is everybody except the person with disability. So that's the control issue. Who inherits on the death of the person with a disability? So that's where I'm giving the big shout out to CalABLE. It's not going to be Medi-Cal except under very limited circumstances. And also the third party trust. When we do a third party trust, if it's a beneficiary with capacity, we ask them, you know, when you die, who would you like to have the assets? And I've had people beneficiaries who are married with children, and they say, well, my spouse and my children, just like anybody else would say. Or if they don't have capacity, then I say to the person creating it, like the parents, what should happen to this money when Johnny's not with us? And they say, well, I want my other children to have it, or something like that. So there's a lot of flexibility with what happens to the money when Medi-Cal doesn't grab it all. We put it in the first party trust as well, but we know as a practical matter that the money, probably it would be better off if it was spent long before Medi-Cal could get their reimbursements. So, and how much can fund in a year? The $15,000 is a limit, except for people who are working, and that's a good new legislation that came. And the third party can have as much money as anybody wants to put in it. There's an unlimited amount. And is there a cap on how much can be in that? I mean, it really means in the trust account. And there's a $100,000 limitation that Carrie went over. And there's no cap on the special needs trust. Okay, the income tax, there's a big difference here. The ABLE account is a tax advantage, as Carrie said. The special needs trust is a trust, and trusts have higher income tax rates. Their brackets that are compressed. The trust will get to the top income tax rate really soon if it has a lot of income. So the investments in the third party trust should be perhaps in tax exempt things or some other way, but it's going to be taxed a lot. It can distribute some income to the beneficiary to buy stuff or go in the ABLE account, but the taxes on the third party are going to be more severe. And the distributions, the qualified disability expenses, what we've always thought about the qualified disability expenses is that the ABLE account is 529A under the Internal Revenue Code. And we feel that the IRS probably has a lot of other things that they're more worried about than ABLE accounts. So the fact of auditing the ABLE account is probably unlikely. I don't know. I think Carrie's right. It shouldn't be used to take the whole family to Disneyland. It, it should be for the benefit of the beneficiary. But on the special needs trust, Social Security is looking at those. The third parties, not so much, but they could audit them. And what happens if they audit and benefits, has been paid out for wrong things, then the person will become unable to be qualified for Social Security. They might look back and try to recoup Social Security, SSI, paid out when the trust had become disqualified. So the Social Security Administration is becoming a really big pain to deal with. So we're glad they're not as involved, hopefully, with ABLE. And the effect of paying for food and shelter, there's no penalty in the ABLE account, and there definitely is in the SSI. So let's see, we're getting pretty close to the question and answer period. So the planning strategies, and I think we've hit a lot of them. If the beneficiary receives cash, then that's going to reduce their SSI dollar for dollar. And that is the hardest thing for the trustees to really understand. And it is a very hard thing for the beneficiaries to understand as well. And now we have the ability of putting money into the ABLE account. When ABLE accounts first came out, we attorneys were wondering whether it could be really true that we could sort of launder the money through the ABLE account. But we got a really good letter in 2017, an opinion from Social Security essentially saying, and if you read it, it says, like funds in and contributions to the ABLE account, distributions from the ABLE account are not included in the beneficiary's taxable income, and they're not counted as income for eligibility. So there is a way to run things through the ABLE account, which has been approved by Social Security, and that's really a good thing. And the housing thing I've talked about before.
The first question is, Margaret, you mentioned that special needs trusts cannot pay for things that Social Security should pay for, like food and shelter. Given the fact that many people, oftentimes, the cost of those things may exceed what their actual benefits are, is there any way around that?
Okay, so the special needs trust can pay for food and shelter if the beneficiary is willing to take a reduction about 1/3 of their SSI payment. And the big SSI payment is, somewhere over $900 a month. So if the beneficiary and the trustee decide that that's, they're willing to give up about $300 for that, they can. But if indeed that's paid for out of the trust, then there will be a reduction in the Social Security benefit. SSI is what I mean.
If we die and have life insurance for our child, we would use the first party special needs trust ? They would have to pay back Medi-Cal as well?
If you own the life insurance policy, you don't have to go through the first party. You can name the special needs trust as the beneficiary of your policy. And that's exactly what you would want to do. You do not want that to become a first party. So I have clients where somebody named a person who was on SSI, and unfortunately it would go in the first party if that's what happened in the beneficiary designation. But part of the estate planning for people who create a special needs trust for somebody in their family is to check your life insurance beneficiaries, your IRA, your 401k, your retirement plan beneficiaries, and make totally sure that you haven't named an individual who is on SSI as the individual beneficiary. You can always name the trust.
Thank you. If a 529 plan was rolled over to the ABLE account and that child died with a disability, can the remainder go into another 529 for the other siblings?
So currently, there is only the ability to roll over from 529 to ABLE, not vice versa. You can roll over ABLE to ABLE, but you wouldn't be able to, in the reverse.
So just a follow-up, though.
Yeah.
After a person with an ABLE account dies, that money gets returned, correct?
So a couple of things. So once the person, there isn't the ability to name a successor beneficiary. There's a couple of things that the law says. One is that if there are any qualified disability expenses that are outstanding, funeral and burial costs are considered those as well. You can continue to pay those out of the ABLE account. The law also does say that you can transfer the funds to a sibling who's ABLE eligible or has an ABLE account. Pending any of that, however, if you have a will, then it's specified in the will that it will be distributed to heirs, and that would happen accordingly. But be aware that you're subject to a tax penalty potentially, because at that point it's not being used for the benefit of the beneficiary.
Can you give an example of the income tax rate on a third-party special needs trust? Example, a $100,000 trust yields roughly what amount in tax?
I cannot do that. Lawyers are not numbers people. You can talk to your accountant. The brackets are compressed. The rates are, I don't know what the rates are exactly. Maybe this gentleman knows, I don't know.
It varies.
Okay. Yeah. This question is for Margaret. How much should I anticipate paying to create a special needs trust?
That's going to vary depending on, attorneys where they are. Bay Area is more expensive. I would say that it would be somewhere in the range of $2,000, $1,500, $2,000 or more, depending on how complicated it is. It's not cheap, and it's just an investment in your child's future.
If getting child support for special needs adult, if put into special needs trust, does it still affect SSI benefits?
Okay, so that is a pretty complicated area. You have to stay, if the parents just agree to fund a special needs trust so it never goes anywhere near the child, that is probably a way to make sure the benefits maintain. We don't want the child support going directly to the disabled person. So it's kind of complicated, and it depends on agreement between fighting spouses, but it needs to be carefully looked at. The special needs attorney needs to be involved with the divorce attorneys in setting something like that up.
Okay. Can the trustee of a special needs trust deposit trust money in the beneficiary's ABLE account?
Yes, absolutely. They can transfer it, obviously. They have to they need to be mindful of the $15,000 a year limitation. And as I gave my rent example, that's over the entire year. So this family was depositing a total of $12,000. They couldn't say, well, $1,000 this month, but yes, and that was what the Social Security Administration approved of.
Okay.
I would add one other comment. The trust that I'm drafting now specifically say that the trustee can deposit in the ABLE account. Obviously, the ones that were drafted 10 years ago don't say that. We don't think it's a problem because it is approved by Social Security, but any new trusts, I would recommend making sure that that trustee is absolutely authorized to put money in the ABLE account.
Okay, the last question. The annual reporting from CalABLE for completing taxes, both federal and state?
So the only reporting that happens tax-wise is when we just went through the tax season, and so as you're doing that, you will report the ABLE account as to, for instance, in some states, people are getting a tax credit or a tax deduction like we're trying to pursue. And so in that instance, by listing the ABLE account, then you would potentially receive, if that was available in your state, a tax incentive of some sort. But my son has an account. We went through, we use TurboTax, and we went through, it was pretty straightforward. They asked, do you have an ABLE account? And, there's not much in it, but reported the ABLE account, and that was kind of it. It's kind of, do you have one?
But not any taxable.
But no, there's no taxable income, correct.
The UC Davis Mind Institute was created in 1998 with a promise to find cures for neurodevelopmental disorders. Every day, our physicians and researchers come closer to fulfilling that promise. Their groundbreaking research on autism, Fragile X syndrome, chromosome 22q11.2 deletion syndrome, ADHD, and other brain disorders are helping children achieve their fullest potential. Please visit our website to find out more about current studies, upcoming events, and how you can help make a difference.